Good morning, everyone. Thank you so much for joining us today. My name is Isosa Charles, the Virtual Event Case Officer. May I please request that the main parties kindly turn on their cameras and also unmute themselves. The inspector will be starting the inquiry shortly. Thank you.
Morning.
Good morning. Finally.
Absolutely, finally.
I think the massive adjournment in between makes it what's really an 8-day, 9-day inquiry just feel like such a long expanse of time, isn't it?
Yes, it is. I confess it is. It's not been easy.
I've just emailed across my closing. Has it landed with you?
Yes, I've just
You've got it. Okay.
I've just got that. And I will do the same to. I mean, I've literally in the last 5 minutes sent mine to the inspector. So, well, I've sent it to Pin. So, she may have a little delay before she actually gets mine.
Right.
So we may need to pause after yours. I don't know what she'll want to do. Let me just send you.
See, we've both gone for the positivity of the end of inquiry on Friday, and you're wearing something floral, and I've got a nice floral tie on. There's a positive upbeat.
Hang on. I'm suffering from lack of sleep.
Oh dear.
So I just want to make sure I've. Why isn't my sent box telling me?
Good morning.
Good morning, ma'am.
Good morning, Mum. There's another one.
Good morning. Welcome back to the final day of this inquiry. Can you see and hear me all right?
Yes, ma'am.
Good. Just check who we've got here today.
2 exhausted advocates.
Were you up very late last night? Dare I ask? Or up early this morning, maybe?
I had an interesting tube journey home at about midnight last night. That's all I can say, Mum.
Oh.
With
What
quite a lot
happened?
of revellers.
Oh, really?
It was quite exciting. I got into a game, and the game was guess where she was born, and then it was guess what she does for a living.
What about you?
Yes, it's hilarious. Anyway, sorry,
no.
I digress.
So you were being hassled on your way home?
Well, no, they were fine. Just the exuberance of youth.
Did they accurately guess what you'd been doing with your week?
We did eventually get to the fact that I was a planning lawyer, but I certainly didn't reveal what I'd been doing. It was a fairly intense couple of 9 tube stops, something like that. Anyway, sorry.
Maybe they should be the advocates if they can cross-examine and get to planning barrister quickly.
Get to a conclusion within 9 underground stops. Very good. Excellent. Oh, well, I'm glad you're still laughing even at this point in proceedings. So well done. Right. So I've had this completed section 106 all signed, sealed and delivered this morning. So that's good. We've got just the closings left. But before we go on to that, I'll just run through a few last little bits that I thought I should mention. First of all, I thought I should just let you know about my site visit. So I did the formal site visit in the interim between the two sittings. so that's done. But I may or may not go back depending on how writing up goes and whether there's anything I want to double check. So that would just be an unaccompanied site visit. I would just go as and when, just in case there is any members of the public listening that, you know, if they see me around Temple Combe again, they know why I'm there. So that's done. And then just moving on to costs. Are we anticipating any costs from either side?
No, ma'am.
No, ma'am.
No. Okay. And finally, is there anybody who hasn't spoken or wishes to speak before we get to the end of the inquiry today? If you could let me know now. No, that looks like a no. Okay. Right, that's me done. Was there anything else from either side that you think we need to talk about this morning?
No, ma'am.
No.
No, thank you, ma'am. Sorry.
I'm sorry to ask, but can I just have 2 seconds to go and grab something from the printer? I'm sorry, it's not something. It's Mr. Robson's closing. I'd just like to have a just like to have a printed copy, if you don't mind, in front of me. And my attempts to get somebody else to do that for me hasn't met with success. So I'm going to have to do it myself. Thank you. I'll be back in 1 second.
No
I'm
problem.
so sorry.
Right, so I've got your closing as well, Mr. Robson. So
Thank you, ma'am.
that's good. Mary Kit completely left.
Oh, no, ma'am. I can see her as an attendee on my.
Oh, really? Oh, yeah, okay. Oh, yeah.
So sorry.
Oh, she's back.
So sorry, ma'am.
That's all right.
Mr. Robson, thank you very
No
much
problem.
for giving me that chance.
Okay, so if you're all good to go,
Yes, ma'am.
yeah, over to you then, Mr. Robson.
Thank you. This is not an appropriate location for this scale of development, whether in terms of the site specifics or the settlement. The council's position on this scheme has been consistent throughout, from the pre-application advice on the initial scheme for 80 units, through the various amendments to the scheme, the officer report and decision notice, and finally at this appeal. Ma'am, there are footnotes attached which you will note. I don't intend to read those out as well. They're merely for when you go back to there's references. The clear position being that, 1, the proposal causes less than substantial harm to the grade 2-star listed Manor House, and that this justifies refusal in its own right. The visual impact would be a very substantial adverse effect on the users of the public right-of-way, 2912 and the substantial adverse effect on those using East Street and Temple Lane. In landscape terms, the development would cause a moderate adverse effect. And finally, the site would not comply with the strategic policies SS1, SS2 and SS5 because it would not be commensurate with the scale of the settlement. All that has changed over the life of this case is that the council can now show a 5-year supply, meaning these policies carry their full weight. There are several agreed matters that ought to be set out from the beginning. The first of which is that Temple Combe is a sustainable location. The council has never suggested otherwise, but that does not mean that all development in Temple Combe is therefore sustainable. Secondly, in the HELAR, the site was identified for 35 units. The HELAR is not a definitive precursor to a consent or an allocation, as Mr. Orton, JO, and Mr. Kenyon, DK, agree. As Mr. Kenyon made clear in his written and oral evidence, the HELAR is a high-level technical study, although it is noted that even at this stage, the HELAR records that there needs to be full consideration of the potential impact on the Grade 2-star Manor House. Thirdly, as Mr. Kenyon made clear in cross-examination, on the back of the HELAR, it is not definitive on whether the site would be suitable for 35, less than 35, or more than 35. Importantly, his answer continued, although the second part of the answer was conveniently ignored by Ms. Cook in the rest of the cross-examination, that the detailed assessment would need to be done on any application. It is a mischaracterisation of his evidence to say, as Ms. Cook sought to push in cross-examination, that the difference between the council and the appellant is whether the site is suitable for 25 units. That is not the question at this appeal. You, ma'am, must determine whether this application should be permitted. Neither the HELAR nor Mr. Kenyon tell you, ma'am, what is an acceptable quantum of development on this site. It is a starting point. Such an assessment can only be done through detailed analysis of any proposed scheme, as has been done at this inquiry. Heritage. It is agreed between Ms. Wedd and Mr. Smith that the proposed development causes less than substantial harm to the Grade 2-star listed building. As I will set out later in the planning balance section, it is also agreed that this harm must be given considerable importance and weight, and that's the established case law of Barnwell Manor. It should also be noted at the outset that neither party criticises the methodology of the other. The Manor House has a lengthy and important history justifying its listing as a Grade 2-star building. This confirms that it is a particularly important building of more than special interest. Only 5.8% of listed buildings are Grade 2-star. The history of the use of the site dates to the 12th century. The manor house and barn that we see today were constructed at the same time in the late 16th century. It probably incorporates the footings and materials from the earlier Knights Templar building. What is equally clear and accepted by Mr. Smith in cross-examination is that since the 12th century, through the construction of the listed manor house and up to the present day, the site has a long-established working link to the agricultural landscape. Some important points were agreed by Mr. Smith in cross-examination about the nature of this building. Firstly, the whole of the building is listed, and therefore the house and the barn receive the same degree of protection from the Grade 2-star listing. The barn itself is therefore a building of very high significance. The barn was either used for storage of produce or as a byre to keep cattle. Either way, the produce would be collected from the nearby fields or the cattle grazed nearby, including the appeal site. There is evidence that the appeal site was farmed since the post-medieval period and most likely back to the use of the manor house by the Knights Templar. The part of the barn that faces to the appeal site is a later addition. However, later should not connote recent. It was agreed that it was constructed in the late 18th or early 19th century. The later addition, therefore, is likely to have operated as a barn or byre. Its function would explain the lack of architectural flourishes on the building. We will return to the importance of this point in due course. That an extension was needed to the barn in the late 18th or early 19th century was a sign that the manor house was the centre of an active and prosperous farm. The orchard, shown on the Tithe and OS maps, was a productive agricultural use of the neighbouring land. What is equally clear from these historic maps is that when one looks at the nature of the field boundaries and consider the agricultural focus of Temple Combe, the fields surrounding the manor farm, that should be the manor house, are in agricultural use. This is an agricultural landscape and has been established as such for nearly 1,000 years. It is agreed, and it can be appreciated from a walk around the listed building, that it is a building of high historical significance with a deep relationship to the surrounding agricultural land that includes the appeal site. The relationship with this agricultural land was keenly understood by Historic England and made clear in their consultation responses. When assessing the 80-unit scheme, they commented that the landscape surrounding Manor Farm, including the appeal site, quote, forms a clear element of the experience and appreciation of the asset, the last vestiges of its rural setting, and therefore, due to its rarity, holds greater value in terms of the contribution it makes to the significance of the asset. Going on to find that the surrounding landscape, which is including the appeal site, is the last remaining link to the rural landscape. On the 76-unit scheme, they commented that the manor house derives significance from its association with the rural setting. And finally, on the 60-unit scheme, Historic England concluded that the proposed master plan under consideration at the appeal, and the footnote there is that Historic England were considering the same public open space, but the master plan has changed slightly, and you've got those amendments. It retains a more meaningful link to the rural setting. However, importantly, they conclude that the development still causes less than substantial harm when the letter refers to weighing the residual harm in the paragraph 196 balance. The appellant's initial case to reach the strained conclusion of less than substantial harm at the lower end of the spectrum relies upon a contorted interpretation of these letters. Mr. Smith's position in examination in chief and in his proof of evidence was that the reference to in the Historic England letters to a rural setting meant that they required only a link between the listed building and green space, and that the agricultural nature of the surrounding land was not key to the significance of the asset. It is a misplaced and contorted interpretation, and one that was rightly abandoned in cross-examination. When one takes the agreed position set out in paragraph 8 above and the wording of the letters, it is clear that the references to rural setting are inclusive of the agricultural use of the land. It is not saying that the agricultural use of the land is not part of the significance of the asset. The surrounding land has been in agricultural use for nearly 1,000 years. The manor house was an active and prosperous farm since 1615 to 1620. The surrounding fields have historically been in agricultural use. The link between the listed building and the agricultural land on which the appeal site sits, as Ms. Wedd concludes in her proof of evidence, is a fundamental and vital contribution to the high significance of the heritage asset as part of its setting. Mr. Smith's evidence suffered from internal inconsistencies. His strained interpretation of the Historic England letters did not match his conclusion in parts of his proof of evidence, particularly at paragraph 3.47. There he accepts that the legibility of the building as a farmstead is important. Plainly, agricultural land surrounding the building will assist in that legibility. This legibility is detracted by the modern 20th century buildings, and that should be the dwellings rather than buildings, because I get onto the barns in a moment. It was agreed, therefore, that as agricultural land is removed from the setting through development, what agricultural land remains increases in significance. That is precisely what has happened to the point where the appeal site is the last remaining link to the historical agricultural setting, considerably elevating its contribution to the significance of the asset. The effect of this development would be to remove this last remaining link. The public open space provided by the scheme would, as Ms. Wedd was clear, be pretty and it would be green, but fundamentally it would not be agricultural. It would sever the agricultural link that is agreed is important to the legibility of this two-star asset. This important point was not properly considered by the appellant. Fortunately, clear evidence on it has been given to the inquiry by Ms. Wedd. In fact, Mr. Smith stands alone in failing to assess cumulative change. And there's a reference there, ma'am, to the definition of the term in the practice advice from Historic England. Historic England plainly considered cumulative change in their letters, as seen in the excerpts at paragraph 9 above. In seeking to artificially reduce the importance of the appeal site to the significance of the asset, Mr. Smith took a narrow view of the strategic views of the farm. And ma'am, you may recall the plan with the different brown areas in Mr. Smith's evidence. The reference is there for when you're writing up. Mr. Smith's approach, he accepted in cross-examination, did not consider lateral spread views, i.e. not just the views when one looks directly at the asset, but what else one sees at the same time as the asset. Lateral spread views are important, as the Historic England guidance makes clear. It is in these that one appreciates the part of the setting that includes the existing modern barns. Whilst they may be utilitarian, they are the cousin of the listed barn and provide legibility to its agricultural heritage. It is only on the complete understanding of the importance to the significance of the manor house, of the setting and the appeal site, that one can properly go on to assess impact. That necessarily involves the due consideration of the agricultural link, the role of cumulative change, and lateral spread views. The complete consideration advanced by Ms. Wedd, as opposed to that partial analysis of Mr. Smith. The assessment of impact can, to some extent, be judged on site. Nonetheless, the use of photo montages is a helpful tool. Indeed, it was suggested by Historic England in their letter of the 22nd of April 2020 that montages be provided to better understand the impact of the scheme from the strategic viewpoint. The appellant's photo montages were produced for the appeal with photos taken in October 2020. From his answers in cross-examination, Mr. Smith was not involved in the production and signing off of the montages. He did, however, give them full consideration in the preparation of his proof. Nonetheless, he failed to raise with his team that the photo montages from Strategic Viewpoint 6 was produced to exclude the important face of the listed building from it. What was agreed with Mr. Smith in cross-examination is that Viewpoint 6 shows that the proposed planting that is to mitigate landscape impact will block views of the listed building. It is this unavoidable consequence of the development on this site that the appellant cannot avoid or cannot change. The landscape harm of bringing the development over the plateau of the site must be mitigated. To mitigate these landscape effects, large and uncharacteristic planting is proposed on the boundary and internally to the site. The consequence of this is that the listed building is screened from view. If the boundary planting is reduced, the landscape harm is not mitigated. And whilst one can then see the listed building, it is across maintained public amenity space rather than farmland, and in the context of 60 homes with the associated movement, noise and paraphernalia. It is a site that is simply not suited to this scale of development. Back to the appellant's curious photo montages. One such instance of favourable editing may just be careless. However, there is a second photo montage that also selectively edited in a failed attempt to benefit the appellant's case. Photo montage viewpoint 8 includes the most bizarre manipulation. The base photograph onto which the montage is placed is taken of the site with cows in the view. It includes a cow that is stood up to block the view of the gable end of the listed building. And I should have changed the sentence there. I don't think the cow deliberately stood up to block the view of the listed building. I think that there is a cow stood up that does block the view. And that's a drafting error on my part. I'm not suggesting it was put there by the appellant. I'm suggesting that it is in the photo blocking the view. That's eat shoots and leaves error there, I think, on my part. However, when the dwellings are superimposed onto the photo montage, the cow is edited out and the listed building is visible. The reality is that the listed building can be seen from this viewpoint. Its relationship to the agricultural landscape can be appreciated, and the dwellings coming down the slope and dominating the view, which is lateral spread, will negatively influence how the barn is appreciated. The final selective edit in the photo montages on viewpoint 10 has the photographer at the far right-hand side of the road, which conveniently means the listed building is hidden behind trees in the verge. A simple half step to the left would show that the listed building is fully appreciated across the farmland. No doubt, ma'am, you will have taken this in on the site visit. Mr. Smith sought to argue unconvincingly that if the viewer approached the manor house down Bowden Road, seeing the front of the house, walking north down the high street and seeing the side of the barn, the same viewer would not recognise the gable end visible from the footpath as part of the listed building. With respect, and again this will have been appreciated on site, if that route is followed, the different building materials and the experience of the walk make it inconceivable that the viewer would not recognise the gable end as part of this listed building. That the gable end is plain is to be expected for a barn. It emphasises its agricultural nature and link to farming. It is also experienced as a part of the whole, including the higher status manor house. The impacts of the development on the significance of the manor house are set out in Ms. Wedd's proof of evidence at section 4. The development will remove the last remaining link to the agricultural surroundings. It will be visually intrusive and urbanise its setting. It will further erode the listed building's isolation. It is for these reasons that Ms. Wedd concluded, quite appropriately, that the harm to the listed building is at the moderate to high end of less than substantial. As with landscape, as with heritage, the difference between the parties are matters of judgment rather than methodology. There are also some important parts of analysis, again relating to the link of the listed building, that Mr. Williams acknowledges did not form part of his assessment. The methodology for arriving at the overall conclusion on landscape and visual effects is set out in the flow diagrams that no doubt, Ma'am, you're familiar with from Glivia 3 and included in the core documents. Throughout this process, Mr. Williams underestimates key points of assessment. Whilst the differences between Mr. Williams and Mr. Potterton may only be slight, as Mr. Williams acknowledges, it is these little differences in parts of the assessment that affect the final judgment. As will be appreciated on site, one of the characters of it are the plateau and the slope that goes down to the valley bottom. The development comes over the plateau and down the slope. There will be extensive cut and fill engineering of over 7 metres in range. Sorry, Ma'am, if you could delete over there. That's visible on the plan listed there at CD 10.02, Ma'am, but it shouldn't be over 7 metres. If consent is granted, that will fundamentally alter this landscape. It is not development that sits naturally into the existing landscape or topography. It was agreed that this is a transitional site that moves from the dwellings to the agricultural and rural surroundings. It was also agreed that the site is not a valued landscape. Nonetheless, Mr. Williams did agree in cross-examination that he had applied the methodology of box 5.1 in Glivia as the considerations to identify the value of that landscape. Just because the site is not valued in paragraph 170 terms does not mean it is of no value. There is much agreement on some of the considerations of value, and the difference lies in the appreciation of scenic quality and rarity. This is a tranquil site that is representative of a quiet pastoral landscape. It is also a site with a strong historic link to a Grade 2 star listed building, considerations which, in Mr. Potterton's evidence, push the value of the site to medium. In landscape character terms, the development will result in a moderate adverse degree of harm. This comes from the substantial changes to the site through the development itself and through the public open space. The maintained the landscape, which is a reference to the public open space, with a long, hard-surfaced footpath snaking through it, also involving significant cut and fill, will significantly impact on the landscape character. The proposed mitigation of tree planting internal to the site is also uncharacteristic of the surrounding area. As an agricultural landscape, there are a limited number of field trees to maximise the productive farming space of each field. It will in effect bring the urban edge forward through the housing and the amenity land, without improving the transition to the rural landscape. Mr. Williams eventually agreeing the obvious point in cross-examination that the proposed open space with footpath and planting is not comparable with pasture land. Turning to visual impact, again, this can be assessed on site. Whilst the photo montages are of little use, see above, the cross-sections are even less helpful. It was noticeable how little they were referenced in evidence, and their value for money must be low. They confirm the obvious: the site is on a slope. What is apparent from the topography of the land is that the development will appear to spill down the slope that separates Temple Combe from its plateau and the valley sides. This encroachment will be easily appreciated from the highly sensitive users that take the footpath and surrounding lanes, particularly East Street and Temple Lane. Mr. Potterton's table at his proof of evidence, page 16, shows the fine margins between his assessment of visual impact and Mr. Williams. In reality, the difference is that Mr. Potterton takes the most sensitive receptor at each site, whereas Mr. Williams conveniently takes a wide range of sensitivities. Impact should be assessed against the most sensitive receptor at each position. The overall conclusion of Mr. Potterton is that the development results in a very substantial adverse effect on those using public right-of-way 2912 and substantial adverse on those living beside the site and using East Street and Temple Lane. 5-year supply. The methodology for calculating 5-year supply is well understood by both parties. The starting point is to identify the requirement. At the start of the inquiry, the inspector was presented by the local planning authority with a single requirement on which to base the 5-year supply calculation. Mr. Orton put forward 18 different calculations based upon 4 different approaches to requirement: local plan plus 5% buffer and shortfall, plus 10% and shortfall, standard method plus 5 and standard method plus 10. It was eventually agreed in cross-examination that the only requirement on which the 5-year supply calculation should be based is a standard method plus 5% buffer. By the appellant, and plus 10% buffer by the, there's a sentence missing there, ma'am. If I could ask you to add that in.
Mm-hmm. So
is a standard
24.
method plus 5% buffer on the LPA's case.
Yeah.
and or 10% buffer on the appellants. Sorry, ma'am, there's an addition that has escaped editing.
The appellant's case. Yeah.
Just to be clear, Mr. Orton definitely did not agree it was standard method plus 5. His was standard method
Did
plus 10.
wonder. Yeah, that makes more sense.
The requirement put forward by Mrs. Alexander from the outset. That requirement is from a straightforward application of paragraph 73 of the framework. The housing requirement policies in the local plan are more than 5 years old, having been adopted in March 2015. There's not been a footnote 37 review of those policies. As a result, the 5-year supply is calculated, that's an odd sentence, the 5-year supply is calculated on the basis of the standard method.
Yep.
Sorry, the late night proofreading, forgive me for this small
Yeah, I
misstep.
don't know how you get these things sorted so quick. It takes me months.
It is accepted that the local plan requirement remains in place, and that goes to the weight that is to be given to market and affordable housing, but it is emphatically not the basis for calculating the housing requirement for 5-year supply. Following that agreement, the Middleton Cheney appeal decision is of no assistance to you, ma'am. That appeal decision was referenced by the appellant to support the proposition that the housing requirement could be used to calculate 5-year supply, notwithstanding that the policies are more than 5 years old and have not been subject to a footnote 37 review. This, on the appellant's case, was because the housing requirement was higher than the standard method local housing need, and therefore would better boost the supply of homes. This argument is wrong on several levels. There had been a footnote 37 review in Northamptonshire, which is Middleton Cheney, that found the local plan housing requirement did not need updating. The paragraph references there, ma'am, to the paragraphs in the appeal decision. There were specific issues relating to the Oxcam corridor, and the inspector there recognised that the case was an unusual circumstance. There are significant factual differences. Mercifully, because of Mr. Orton's concession on the calculation of supply, that appeal decision is of no importance to this appeal other than as an example of the appellant's desperate approach to lower the 5-year supply by hook or by crook. The next area of disagreement relates to the buffer. The case as presented either follow the cases as presented either follow the MPPF or they do not. The council's case that the buffer should be 5% is based on a straightforward application of paragraph 73. It is agreed that the HDT results for the SSDC were 95%, and as a result, the 5% buffer applies. It is the appellant's case that the inspector should deviate from national policy. The arguments put forward for such a deviation are totally without merit. Firstly, the 10% buffer applies only where an authority seeks to rely on a recently adopted plan, agreed not to be the case here, or on an annual position statement. An APS is a document that follows a process that is set down in paragraph 74 of the framework. It is required to be produced through engagement with developers and others who have an impact on delivery, and Mr. Orton accepted that the SSDC HLS paper is produced in this way. The document must be submitted to the Secretary of State for consideration. SSDC has never submitted its HLS assessment to the Secretary of State. Mr. Orton accepts that this requirement is not met. It is therefore impossible for the final requirement of paragraph 74 to be met, that the recommendations of the Secretary of State are accepted. If it is not submitted for assessment, recommendations cannot be made. In MPPF terms, the SSDC, not SSDD, SSDC annual HLS paper is not an APS. I mean, that's a sentence of high initialisms. If Mr. Orton's argument then took a trip to the playground, essentially that it wasn't fair that authorities that submit to the Secretary of State get a 10% buffer, whilst those who don't get 5%. Firstly, a Section 78 appeal is manifestly not the forum for rewriting national policy. Secondly, the point is misguided. The APS fixes a local planning authority's 5-year supply for a year. It cannot be challenged. For that benefit, the local authority submits to a 10% buffer. A council that seeks to prove its 5-year supply on the basis of the most up-to-date information, which Mr. Orton accepted SSDC was doing, caveat, of course, as you'll know, ma'am, although he didn't agree that the information was correct. He agreed that's what we were trying to do. We just disagreed on the outcome. That authority can have its 5-year supply challenged throughout. There is no protection. The final argument for Mr. Orton that some sort of negative inference should be drawn from not submitting an APS Again, this is a weak point. There is no obligation to submit an APS. In fact, it has not proved to be a wildly popular mechanism, Only 3 councils applied by the 1st of April 2021, and that's published by the government, MARM online.
There's more than that on
A local
this.
planning authority can choose not to submit an APS for a whole host of reasons, as it seems many local authorities do. Most bizarrely, Mr. Orton characterised it as semantics that the SSDC HLS position paper was not an APS. I personally don't fully comprehend how not submitting a document to the Secretary of State can be characterised as semantics. The material consideration that Mr. Orton points to in support of his argument to deviate from national policy is that the 10% buffer provides more flexibility given COVID and phosphates in this authority. To be clear, there is no basis in national policy for such a consideration. Flexibility is provided through the affordability adjustment, which also factors in past under delivery as part of the standard method calculation. Any need to boost delivery due to undersupply from COVID will be wrapped up in the standard method calculation. Should be a full stop there. It is also provided through the 5% non-implementation rate by the council. Finally, the appellant argues that there is a moral argument to apply the 10% buffer to significantly boost the supply of homes. This is a misunderstanding of national policy. It is clear that the government considers the use of the standard method to boost the supply of housing, since it is requiring all new plans to be on the basis of the standard method unless there are exceptional circumstances. These are not material considerations that could justify a deviation from national policy. It was agreed between the parties that a windfall allowance of 20 DPA should be applied. This is a conservative allowance when one considers that the average windfall in the last years is 100 DPA. The council applies a non-implementation rate of 5% to the supply. There is no policy requirement for a non-implementation rate. The rate to be applied is a matter of planning judgment. The appellant argues for an 11% non-implementation rate. There is no reasonable basis for this to be applied, for this 11% to be applied. It is argued that it should be to make up the 8.4% removed from the HDT, plus the council's 5%. This should be applied at 13% for 2 years and 10% for 3 years, giving an average of 11%. It must be stressed that there is no policy or guidance for such a complicated mathematical exercise. The 8.4% reduction in the HDT was a decision of central government taken to allow for COVID. There is no requirement to make up that 8.4% over the next 2 years. The allowance for COVID is to equate for a single month of reduced delivery. This is a justified approach to the work time lost to lockdowns earlier in the pandemic. The 5% non-implementation rate should be preferred. This is a contortion that is put in place, this is a reference to the 11%, is a contortion that is put in place solely to achieve the appellant's objective of getting the supply of housing land below 5 years. It has no solid foundation and should be rejected. The Scott schedule was examined in detail, and the differences between the parties are now clear. There are points of principle, though, through which that site-by-site assessment should be made. 1. That the test is one of deliverability, and the term is defined in the framework glossary and set out there, Marm, for ease. Mr. Orton accepted in terms that being available now is coloured by the end of the sentence. That is a realistic prospect of delivering houses on the site within 5 years. This is particularly important when it comes to phosphate sites. Where there is a full consent, then it is presumed to be deliverable unless there is clear evidence otherwise. And those sites are listed at the footnote, Ma'am. This includes phosphate sites. It is not enough simply to say phosphate sites will not deliver, nor in the case of Fox's Run in Castle Carey, to point to a single letter that raises legal concerns and say this amounts to clear evidence that the site will not deliver in the next 5 years. The letter is 2 years old and no further legal action has been taken. It is not clear evidence that the site will not come forward in the next 5 years to rebut the presumption of deliverability in the framework. At Goldcroft, which benefits from a full permission and therefore the presumption of deliverability absent clear evidence otherwise, the correct approach to the ratio calculation is as set out in Mrs. Alexander's comments on the Scott schedule, supported by the government guidance in the PPG and the Housing Delivery Test Handbook. Progress, Ma'am, is being made on the phosphates issue. The matter is being taken extremely seriously by the Council. The work to find solutions is progressing. The published Phosphate Management Strategy Position Statement, June 2021, is working to a new SPD to deal with mitigation by the end of August this year. excuse me, this shows that it is perfectly reasonable for sites within the phosphates catchment area to be a realistic prospect of housing coming forward within 5 years. Solutions are in fact already being put forward. This includes on-site and off-site mitigation. The Persimmon scheme at land adjacent to Holbear, Fortman Road, Chard, is going back to Regulation Committee later in July. Although this site is not included within the 5-year supply, it shows a solution is possible. Once approved, this site can now come forward more quickly. The proposal agreed with Wessex Water means the foul water will be drained outside the catchment area. Also, the southern phase of the Crewe Cairn site at Taylor Wimpey has a phosphate offset solution, and the reserve matters were approved at committee in March 2021. The applicants have been in discussion with Natural England regarding proposal to show nutrient neutrality, and their plans propose to take land out of agricultural production adjacent to the application site. They've produced a detailed plan as to how it will be managed to achieve nutrient neutrality over a 10-year period. All of the land is owned by the applicant. Natural England have been consulted on the proposals and the Shadow Habitat Regulation Assessment and have stated, land at East Crewe Cairn, nutrient neutrality strategy, Natural England considers that approach taken to calculating the phosphorus budget and mitigation measures for the reserve matters application is robust. The appellant's blanket approach of taking phosphate sites out of the supply is simply not justified. Sites that are in the supply with full permission and with all conditions discharged should not be in dispute. The council's supply should be viewed through the above lens. When it is, the council is able to demonstrate a robust 5-year supply, and that, ma'am, is the table which represents the figures put forward by Mrs. Alexander in the round table yesterday. Planning policy and balance. The application must be determined in accordance with the development plan unless material considerations indicate otherwise. The first exercise, as Mr. Orton agreed, is whether, ma'am, you conclude that the council has a 5-year supply or not, is to undertake the paragraph 196 heritage balance. The less than substantial harm, which is at the moderate to higher end of that spectrum, must be given significant importance and weight, and that should be considerable importance and weight, rather than significant. It is also acknowledged in established authority that where there is harm to a heritage asset, whether a listed building or conservation area, the Listed Building Act's duties produce a strong presumption against the grant of permission. Against that very significant harm, the benefits of the scheme must be weighed. Those benefits are set out in Mr. Kenyon's proof of evidence at 11.5 to 11.10. Market housing is given moderate weight. This is on the basis that the council can demonstrate a 5-year supply, that a local plan review is underway that will refresh the council's spatial strategy, and that a shortfall over the life of the plan of 474 is not significant and will be addressed through the emerging local plan. Affordable housing, significant weight is afforded in recognition of the shortfall of delivery across the district. Public open space is given moderate weight. Although it is mitigation, there will be a limited public benefit from it. Whilst it does not exceed the policy requirement for public open space, this is only in an attempt to, whilst it does exceed the policy requirement for public open space, this is only in an attempt to reduce the harm to the manor house. The benefit should also be limited since in all likelihood, due to its location, it will mainly be used by residents of the new scheme. Economic benefits, great weight in the context of the recovery from the pandemic. And if I may just add there, ma'am, Mr. Kenyon's assessment of weight, I think should be considered as entirely reasonable. This is not an authority seeking to strip out all weight without good reason. He has given a balanced view of the benefits of this scheme. Overall, these benefits do not outweigh the harm to the Grade 2-star listed manor house, and the appeal should be dismissed on that basis. If, ma'am, you conclude that the heritage harm is outweighed by those benefits, then the heritage harm is carried forward to the overall planning balance, and it is the council's case that the balance should be flat as it has a robust 5-year supply. Into that flat planning balance goes the heritage harm, which is given considerable importance and weight, the landscape harm and the conflicts with the strategic policies, the latter of which relates in part to the scale of the development being proposed in relation to Temple Combe. The scheme considered to be commensurate with the scale of the settlement as taken on its own, the proposal represents a growth of 8% in dwellings in the parish and would likely increase the population by 9.2%. Taken together with completions and commitments since 2011, the proposal would represent a growth of 24.1% in dwellings and an increase of population by around 27.6%. Considering the other development schemes at West Street and Threep Road, where decisions are pending, the proposal would result in an overall increase in dwellings by nearly 32% and 36.6% increase in the parish population. This is a significant increase in the size of a single settlement and runs counter to the aims of Policy SS2, a conflict acknowledged in the pre-application discussions, but which now gets full weight in the planning balance in light of the 5-year supply. Policy SS2 must be read in partnership with policies SS1 and SS5. The scheme conflicts with the established settlement hierarchy as a result of the points on scale above. Notwithstanding the points made by Mr. Kenyon on the bullet points requirements of SS2, UMAR must reach a conclusion on the interpretation of this policy. The scheme does not provide employment opportunities in the terms set out in the explanatory text of the local plan, nor does the scheme meet the local housing need of Templecombe. The appellant has provided no needs survey, and the only evidence of need relates to affordable housing. The Home Finder database latest update showing 5 houses needed. This does not justify 21 affordable homes and the 39 market homes put forward on this scheme. The appellant's approach to SS2 would completely denude the policy of any control. Any major development would, on the appellant's case, provide economic benefits, create and enhance facilities by meeting policy requirements, and deliver housing against the district need. There would be no control. This is not the intention of this policy. The development is not in accordance with the development plan. The heritage harm, landscape harm, and conflict with the spatial strategy are not outweighed by the benefits. This is the case whether or not the tilted balance is engaged. On that basis, it is submitted, ma'am, that the appeal should be dismissed. Those, ma'am, are the closing submissions on behalf of the local authority.
Lovely, thank you very much. I just wanted to comment on your paragraph 47.6.
Yes, ma'am.
There are no footnotes in there.
Mm.
You sort of refer to various schemes and so on.
They were the they were the schemes that were referred to by Mrs. Alexander. There was then a debate between Mrs. Alexander and Mr. Orton about the ownership of the land, the mitigation land. You'll recall.
For phosphates.
For that particular site.
But we don't. Is it the case that we don't actually? This was just chat. We don't.
It was. Yeah. I haven't put a footnote because the officer reports weren't put before you, but they were raised as evidence in the inquiry, and so that's as far as I can go. I obviously can't introduce new documents through a closing submission.
No. I was just checking it wasn't an omission, and that was the case.
So yes, ma'am. It's a reference to evidence given, but not
backed up.
documents.
Okay, lovely. Thank you very much. Right. Okay. Ms. Cook, shall we have a brief break before we listen to your closing?
By all means, ma'am. I fear I'm going to be a little longer than I said, but happily, Mr. Robson's been a little shorter. So yeah,
yeah, it's been a little bit, yeah.
So art in brevity, I think I was.
Yes, a comfort break would be welcome. Thank you.
Okay. All right. Let's have a comfort break then, and we'll resume at 11 o'clock.
Thank you.
Thank you, ma'am.
Welcome back.
Thank you, Mum.
Okay, without further ado, then over to you, Ms. Cook.
Thank you very much. So, Mum, I just explained at the beginning that we're starting with heritage, then we go to landscape, then we deal with the relevant development, and we deal with the development plan policies in those sections. Then we turn to housing, land supply, general planning matters and the development plan, and then we get to the 196 balance and then the overall planning balance. So just by way of sort of introduction. Heritage, Ma'am. The illustrative master plan scheme before you now is the product of both pre-app consultation with the council, but more importantly, post-application review, input and meetings with Historic England in conjunction with the council's conservation officer. As statutory consultee, their view should be given great weight, as Ms. Wedd and indeed courts set out in her proof and agreed in cross-examination. After all, Regulation 5.3a of the Town and Country Planning Regs 1990 requires them to be consulted in respect of any development which affects the setting of a Grade 2 star listed building. In my submission, Ms. Wedd did not actually follow the approach she herself advocated. Ms. Wedd accepted her opinion that the appeal proposal was at the moderate to high end of the harm in MPPF 196, the less than substantial harm spectrum. Sorry, there are a few abbreviations here and I haven't included a list, but I hope they're obvious. She accepted, the point is that she accepted that her opinion as to the moderate to high end of the spectrum was at odds with Historic England's guidance to the council. Historic England's final second letter of July the 16th followed several months of negotiation, testing and redesign by the appellant with Historic England's input. I just want to pause there, May. I make reference at the beginning of paragraph 1 to the pre-app consultation, and I just want to respond. This is where you will just need to pick up your pen for a moment, but I just want to respond to the point that my learned friend Mr. Robson has made in his closing submissions at paragraph 2, where he suggested that the council's position has been constant throughout, and he references there the pre-app. And I'm just to say that you will need to look at CD 1.06, which is the council's response on the pre-app in due course. I don't invite you to obviously to do that now, but the officers did not say that the officers would not support the application. The officer who wrote that letter was very careful to distinguish what he thought the members' view was going to be, but he did not suggest that the officers would not support the application. So I just suggest that he's not right to say that they've been consistent throughout. Back to my submissions, paragraph 3. This is not a case where Historic England did not understand perfectly well from the outset the significance of the Grade 2 star manor house listed building potentially affected by the proposal. It's perfectly clear from their 11th of February letter that Historic England's assessment of significance was well informed. Moreover, they recognised at the outset that the, and I quote, complex sat outside the boundaries of Temple Combe settlement until the expansion of the village during the 20th century. During this period, the green rural setting was significantly eroded by modern development. Historic England's view was that the last link held by the property to the rural landscape is the northwest corner of the application site. Although they noted the significant hedge along the boundary of the site, they opined that, and again I quote, the landscape still forms an element of the experience and appreciation of the asset, the last vestiges of its rural setting, and therefore, due to its rarity, holds greater value in terms of the contribution it makes to the asset. That cumulative erosion point and their language echoes the guidance mentioned by both Miss Wedd and Mr. Smith with regard to cumulative impacts. And again, Ma'am, I just ask you to note that judging from paragraph 9 of my learned friend's closing, it's no part of his case in closing to suggest that Historic England didn't understand perfectly well the significance of the building. And as he says in paragraph 9, they plainly considered the cumulative change. The difference between us is his accusation that Mr. Smith didn't consider the cumulative change or the cumulative impact. And I just remind you that, of course, it was that led Mr. Smith to identify the less than significant harm. As Miss Wedd agreed, it was no part of Historic England's case ever to suggest that no residential development could take place within the appeal site. Indeed, it was apparent from the outset that they were, and I quote again, convinced that a less harmful layout can be identified in the application site that would allow for a more meaningful buffer to be created. Historic England explained what they meant, namely that alternative layouts avoiding development in the northwest section while retaining views through the wider countryside would significantly minimise the impact to the highly designated asset. As Ms. Wedd again accepted in cross-examination, Historic England did not express concerns about the complete loss of an agricultural use per se, nor, for example, did they suggest that the buffer must remain in agricultural use, or express any concern about how the unbuilt space might be used. Their fundamental issue was to ensure the layout changed so as to identify a buffer and to establish that buffer in the very particular location they had identified. This first letter set in place a work stream and series of meetings in an effort by the appellant to significantly minimise harm. In the end, in our submission, the 60-unit scheme, exactly that, as we shall set out. In re-examination of Ms. Wedd and indeed cross-examination of Mr. Smith, Mr. Robson established that rural, whether in terms of land use, the point he put in re-examination, or setting, which was the way he put it in cross-examination, would embrace agriculture or agricultural. However, this is, can you delete the not, Mum? This is a long way from being an answer to the differences between Historic England and Ms. Wedd. Historic England were consulted on various layouts on the 80-unit and the 60-unit scheme. Each of these plans showed an area marked Manor Green, which grew larger and larger as the proposed housing was pulled back and removed from the northern part of the site. In each of the three schemes presented, it's perfectly clear that this land was intended to provide amenity open space as opposed to a continuing agricultural use. In response, Historic England did not express an in-principle objection to the loss of all agricultural use or buildings from the appeal site, but rather the issue was whether the extent of Manor Green was sufficient. The precise details of how Manor Green might be finally laid out was never identified as a fundamental issue by the council's conservation officer, any more than it was with or by Historic England. Nor did Mr. Garrett express any concerns about whether the total loss of the agricultural use he didn't express any concerns about either the total loss of the agricultural use or the character of Manor Green. In his single written response, which was on the 60-unit scheme, Mr. Garrett welcomed the removal of all proposed development from the northern part of the site, but thought that the remaining buildings still intruded far too north. Hence the reason for refusal. In their original response, Historic England also advised that a less than harmful scheme that better reveals the significance of the assets could be achieved on the site. Subsequently, in response to the 76-unit layout, they advised the master plan has looked to remove the immediate development adjacent to Manor House. This allows for a greater buffer to be created in views from the house. This is the minimum necessary to preserve the significance to the manor through its setting. Nonetheless, they were concerned about longer range views back towards the site from the east, where they said the manor, I quote again, was visible on the skyline. They advised that a greater green swathe would mean that the manor could be viewed without modern development in the foreground. The following month, Ma'am, at a meeting on the 12th of May, Historic England, the council and the appellant, the latter, were asked to undertake more design work. On the 19th of May, Historic England sent an email identifying the viewpoints they were interested in, asking for basic visualizations / photo montages to be produced. Subsequently, as the appellant's statement of case and the planning statement of common ground set out, the 3D modelling work was undertaken and presented at a meeting with the appellant council and Historic England. The work was incorporated into the DAS addendum, where stills of the model were presented from three viewpoints. These are the viewpoints that Historic England, sorry, I'm digressing, but these are the three viewpoints that Historic England had identified. The locations of which are shown in CD 603 and on the revised 60-unit scheme layout. In response to this final scheme, Historic England advised that the revised master plan allows the listed building to retain, I quote again, a more meaningful link to its rural setting and a more meaningful green space within the setting of the manor. Overall, they considered the reduced density and the maximum two-storey height would create a more gradual transition between development and Manor Green, and that the level of harm had been substantially reduced by the most recent revisions. You, of course, have some further revisions to the master plan, which include increasing front gardens of houses which front onto Manor Green and the relocation of building footprints to increase the visibility towards Manor House. I'm just quoting there from the Statement of Common Ground. In addition, Ma'am, the appeal DAS also confirms the appellant's intention to limit the proposed dwellings that front onto Manor Green and the land to the east to 1.5-storey houses. Miss Wedd did not in her evidence criticise this first Historic England letter, or indeed any of their letters, and I pause just to add, neither does my learned friend in his closing. She did not suggest that they had left anything out of account or point to any error. Indeed, she associated herself with their letters, saying, in general, I agree with the advice they provided in their letters to South Somerset District Council. She suggested that her assessment of the contribution the site makes to the significance of the designated heritage asset chimed with Historic England, except that she did not draw any distinction between the whole site and the northwest corner. In using this language in her proof of evidence, she seemed to be trying to downplay the difference between her opinion and Historic England. In truth, there is a world of difference between a proposal at the lower and higher end of the 196 spectrum. Very sensibly, Miss Wedd accepted in cross-examination that her position in terms of the 196 spectrum was clearly different to that of Historic England. In Miss Wedd's view, any change, and I'm quoting again, productive farmland to suburban amenity space would obliterate its contribution to the significance of Manor House. Her position was also fundamentally at odds, even with the council set out in their statement of case, which acknowledged that some residential development on the appeal site is missing from that, even if a lesser amount on an even larger green swathe. None of the collaboration with Historic England was properly acknowledged by the council or Miss Wedd, and indeed my learned friend in his closing has made no reference to that. It was sidestepped by Miss Wedd, who sought to portray her involvement as simply a fresh pair of eyes. However, the fact that the appellant's advisers worked diligently to respond positively to Historic England's direction that a substantially less harmful scheme could be achieved, and indeed succeeded in substantially reducing the harm, cannot be ignored or set aside. It seems to us that this is very much for Miss Wedd to demonstrate why Historic England and Mrs. Smith are wrong in concluding that the appeal scheme results in no more than a residual or minor harm on the less than substantial 196 spectrum. In my submission, she has not done so. Mr. Smith explained he had visited the site 3 times, taking his own photographs, walked the public footpath to and fro, taking in the kinetic dynamic views. His judgments were not based upon Mr. Williams's photo montages, some of which exclude the designated heritage asset. As he pointed out in cross-examination, neither Historic England nor the council's conservation officer had asked for other photo viewpoints or montages to be produced in the run-up to the appeal. Ms. Wedd criticised the proposed open space as a suburban amenity space, skirted by swales with a hard surface footpath through it. She suggested that the planting of trees, grass and shrubs would be alien. In so doing, ma'am, she ignored the history of farming fruit orchards, notably within the northwest portion of the site adjacent to the Grade 2 Star Manor House, and indeed the wooded areas and treed hedgerows in the area evidenced by Mr. Williams. She also ignored the proposed planting of the hedgerows, although later the concern seemed to be that the hedgerows, left unmanaged, might grow to such an extent as to block the views of the designated heritage asset. She seemed unaware of the extent to which Mr. Williams's proposed landscaping was designed to help frame the views of the designated heritage asset from the public right-of-way. She saw no benefit in the public being able to access the amenity space, using the footpath, and so achieve closer views and therefore potentially a better appreciation of the designated heritage asset. There is no reason why the retained open area in my submission could not provide an attractive amenity space whilst providing a lasting opportunity to better reveal the designated heritage asset, as well as affording strategic views of the designated heritage asset from Historic England's viewpoints 1. And ma'am, that's not that should be Historic England's viewpoints 1, 2 and 3. You'll be able to assess that. Maintaining these viewpoints does not depend on the agricultural use of the land. Rather, it depends more upon keeping that area open, which the 106 obligation clearly achieves by the covenant in Schedule 2 to use it only for open space, recreation and amenity. The 106 also provides for an open space management scheme, which would really ensure that certain hedgerows were managed such that their height did not exceed either a specified height or that they would be regularly pruned. This is within the gift of the council to control, and the management body has to be adequately capitalised. Unlike historic England, Miss Wed was not prepared to countenance the loss of the barn, and the proposed development potentially presented this opportunity to better reveal the designated heritage asset. There is no intention or need to create built facilities in the amenity space. The final details of the layout and the management can be agreed via the reserve matters and through the 106 process. In this respect, Ma'am, Miss Wed's views stand alone, and in our submission, her evidence does not justify you reaching a conclusion which is fundamentally inconsistent with both historic England and indeed the Council's conservation officer. I'm thinking there, Ma'am, about the degree of harm in particular. It was and never has been the Council's case that the whole site or any part of it must remain in agricultural use. The starting point in Miss Wed's assessment of significance that the whole appeal site, including the large utilitarian barn, forms part of a working agricultural landscape, which makes a fundamental and vital contribution to the significance of the designated heritage asset, is unsubstantiated and misconceived, and it's that underpins the differences between the main parties. Although some time was spent on the detailed history of Manor House, there is a lot of common ground between the parties in terms of the significance of the physical assets. They departed only in a few key areas, including crucially the significance that the appeal site plays in the setting of the designated heritage asset and the extent to which the land to the east contributes to its significance. Manor House has very high significant historic, architectural and aesthetic value. Both ranges are part of the Grade 2 style listing. None of the interior historic interest would be diminished by the appeal proposal. None of the principal interest and that interest's legibility from Coombe Hill or the High Street would be affected. The northern survey range is the 17th century building with a later addition, either 18th or 19th century, most likely extended for more barn or byre space. The historic mapping shows the appeal site to have been in agricultural use, including part orchards at one time. This land was sold off in the late 1950s when Manor House became functionally and legally separate and thus a former farmstead. On points of difference in the assessment of significance, Mr. Smith was clear that the identification and role of the primary and secondary contributors to the significance of the listed building, which Mr. Smith used, were part of a hierarchy, and the appeal site forms part of the latter. Another difference, Ma'am, was the 20th century domestication of the original farmstead, the conversion of the farmyard to a garden with raised garden area where washing is hung, planting trees, and the domestic conversion of the barns, with again the enclosures to form separate private curtilages, each with their own gardens and garden boundaries, with a hedgerow or high or low walls. There is no discernible visual or functional connection between each of them now. Nor is there any visual or functional connection between the utilitarian 20th century agricultural barn and the new residential, again enclosed for privacy from the surrounding neighbours, including the agricultural land, and the former domesticated barns and the listed buildings. Mr. Smith rightly considered all this to be an erosion of the legibility of the former farmstead. It's not an appropriate counterpoint or answer to suggest, as Mr. Robson sought to do in cross-examination, that this loss means that the modern barn and agricultural land to the east must therefore be kept in agricultural use. Miss Wedd's assessment that the modern barn and the farmhouse make a low positive contribution to the significance of the listed manor house is simply not accepted, nor is it warranted. They have no aesthetic value. These buildings and their boundaries, especially of the new farmhouse, merely limit and block views of the asset. This is the context in which historic England proposed that the proposal could actually better reveal the asset. Historic England's identification of the viewpoints and the testing of the views of the proposal from them was plainly part of their desire to ensure that the opportunity was taken to better reveal the designated heritage asset. This would have been at the forefront of historic England's thinking if they had took the view, as Miss Wed plainly does, that the listed building is well revealed from the east. Most of Miss Wed's photographs were not taken from the public right-of-way. Indeed, many were zoomed-in shots from within the site that the public do not currently have the opportunity to see. Its visibility, and more importantly, its legibility as part of the Manor House complex, is not apparent from the appeal site and the public right-of-way, as Mr. Smith made clear. Her conclusion, the loss of any farmland not built upon to amenity open space would obliterate its contribution, is simply not borne out. This is not even an elevation with any opening to the east or visual interconnection with the land. The functional connection no longer exists. It's no real surprise that Miss Wed misunderstood the location of the listed buildings in her photographs. Surrounded by later modern farm buildings in the foreground and south, and to the north, modern residential development in very close proximity. From the public right-of-way, it's not easy to read the elevation of the northern wing as part of the listed building. Mr. Williams committed a similar faux pas. In my submission, this just reinforced that Mr. Smith was right to observe in cross-examination the limited legibility of the designated heritage asset from the footpath to the east, which rightly he judged as being far from prominent, in real contrast to the views of the designated heritage asset from the west along Coombe Hill and the High Street. He made the same point about the history and the internal use of the buildings by the knights hospitallers. It's not apparent from the public right of way. Sorry, I meant the internal is not apparent from the public right of way. Surely this is precisely why Historic England saw this proposal as a chance to better reveal the asset from the east. The northern or service range plainly includes this later extension at the eastern elevation, which Mr. Smith accepted was later 18th or early 19th century. He accepted a comparable shape was shown on Miss Wedd's figure 10. It's plainly a building of utilitarian form, very different to the manor house as one would expect. Although from the northwest it reads as a barn, serving the original manor or farm. Mr. Smith rightly noted that this was not the case when viewed from the public right-of-way to the east. The council, through Miss Wedd, were very keen to suggest the focus of the original farmstead would have been the farmland to the east, but the mapping itself does not evidence this. Indeed, Miss Wedd's evidence confirmed that in the late 1950s, land east and west of Manor House was sold off, as well as the two barns, which became separate from the residential properties. Miss Wedd was far more certain that the original preceptory building was siting to the east of Manor House, but Mr. Smith suggested that this was still up in the air, whereas certainly the former chapel would have been to the east. Both experts, like Historic England, recognised that the setting of the listed building had considerably evolved and changed, so that it was now part of the settlement seen in the context of the 20th and 21st century residential development. Miss Wedd's assertion that the harm of the 20th century development was evened out by the Merthyr Guest Hospital was very revealing. The original asset has been redeveloped. Pause. At the end of the last session, Ma'am, I can't remember if we named it actually, but you were given the planning permission. However, Ma'am, in cross-examination, she noted that the rebuilt former hospital was at a respectful distance from the asset and that it is a handsome building of agriculture. In terms of distance to the manor house, it is closer. This is the new Merthyr Guest building. It's closer than the nearest unit shown in the appeal scheme's indicative plan. There's no reason why a well-designed residential development using distinctive materials on the appeal site could not equally perform the same role. Moreover, in this instance, Miss Wedd herself recognised that the potential impact on setting was confined to the setting of one elevation of the service wing, to use her terminology. Its original barns, like the listed building itself, are all in separate residential uses with their own curtilages, boundary walls and hedges to afford privacy to the occupants. Mr. Smith was also a fresh pair of eyes, Ma'am. He made his own assessment of significance and considered that the appeal proposal would result in a minor level of less than substantial harm. Neither he nor Mr. Williams were seeking to dismiss the listed building when describing the eastern elevation as a featureless gable, or hard to spot, as Mr. Williams put it. They were merely describing it as they judged it. No one is salami slicing, as Miss Wedd suggested, and that was a complete mischaracterisation of Mr. Smith's evidence. Mr. Smith's position, all said and done, is similar to that of Historic England, and ultimately we invite you to accept his and their evidence and conclude that overall the proposals can be delivered with causing only minor or low-level harm in 196 terms. Equally, we invite you to accept his evidence that the proposal can indeed make a positive contribution to the character of the asset setting through high-quality design whilst maintaining and safeguarding the strategic views identified by Historic England and so complying with policy EQ3. Although, of course, that's not the end of the story, since the 196 exercise needs to be undertaken, and we come to that in a moment. Landscape. Temple Combe is a hilltop village with much existing development built upon sloping land towards and beyond both sides of Combe Hill and the A357. Despite the visual prominence of the site, this case is not about the visual impacts from the northwest. Sorry, Ma'am, I need to move around. If I sit in, I give you the various paragraph references there to some of the factors that they identified. Meeting biodiversity net gain, zero carbon, changes in the building regulations, CO2 emissions. There's no suggestion that the recommended in-house expertise with respect to viability has been gained or achieved, as it were. Indeed, ma'am, phosphates and COVID pressures, none of which, of course, are reflected in Three Dragons, will simply add to these difficulties of being able to gauge properly projections. The identification of limited players controlling land is another factor that Three Dragons identified, and Mr. Orton's Appendix 14, page 124, identifies just how few key players there are. And in my submission, ma'am, the importance of the projections on the the Brimsmore site illustrates this. At 520 of the report, this is Three Dragons, they recommended a review of the land ownership control as part of the assessment of deliverability. Once again, another lesson not yet learnt, and no evidence that this has been done or how it's been factored into the delivery. Again, Mrs. Alexander dismisses this on the basis that it plays no part in the delivery of the 5-year housing land supply, in other words, to look backwards, but Brimsmore is a case in point. I'll come back to that in a second. At 417, Three Dragons also look at approvals to see how these translate into delivery on the ground, concluding that only 52% of approvals translate into completions. They use that to suggest either more permissions are needed to get the required numbers of homes built, or there needs to be more translation of permissions into delivery. The phosphates issue, about which more later, fundamentally hinders the ability of the council to do the latter. And so issuing permissions on sites not affected by phosphates is a compelling and certain way to offset the increased shortfall in delivery. The council, ma'am, do not make publicly available the forms they relied on or the notes of phone calls to generate some of the, well, I say to generate some, they don't publish those alongside their large sites survey. And although they are referred to in the, I say big, that's confusing, large site survey.
That was my fault for getting big in your mind.
No, I think this is just me getting late at night. Although it was referred to a large site survey, it was not published alongside. Eventually, they produced a table of responses to Origin 3. So this is the Appendix 13, but they never published even then the information that underlay it. The obligation in the PPG is for robust, up-to-date evidence, which needs to be available. Available is the word used in the PPG. The oral excuse given by Mrs. Alexander that it was difficult to provide this information whilst working from home, sorry, that's a non-planning acronym, WFH, whilst working from home and complying with Freedom of Information Act compliance is wholly unconvincing in my submission and unevidenced. Councils are well used to redacting personal information. It's not a new requirement. Moreover, ma'am, a large amount of supply historically has come from small sites, and CD 1107 continues to show a heavy reliance, on small sites. There's no evidence of data cleansing on sites with old planning permissions, which, although implemented some time ago, have stalled since, as the debate about the site now being used as the car park illustrates. Post Three Dragons, ma'am, the picture has got worse. And when I say post Three Dragons, I'm looking now at the 2 years, the 2 assessment years that have followed. Most recently, in the 2019 to 20 housing land supply for the first year, 1,049 was projected, but only 659 completions were achieved. And in 2021, 1,228 completions were projected, and we have only 596 being achieved. And ma'am, I'm just going to pause. I think this is an important footnote. The 2021 completions data in Mrs. Alexander's evidence is the best available evidence of supply in that year. She accepted that yesterday when you you asked that question. We invite you to use it, as Mr. Orton has done, on the larger contested sites where the house builders are clearly most unlikely to have used small private contractors to sign off the new dwellings. You know, it seems the council have got 2 points about the question mark on their completions. One is that some people use independent contractors to sign off, but the large house builders, the volume house builders, do not do that. They use the NHBC schemes. The other concern, of course, was about site visits. And I just want to make an added comment about that. For my part, I can't see how a site visit undertaken months after the base date, 31st of March, helps inform completions as at that base date. It's a nonsense. I think the reason they didn't want to say the completions were certain was because they didn't want us to roll forward into another 5-year housing land supply. So, Ma'am, coming back to my text, Mr. Orton's prediction, I'm 4 lines down in paragraph 69. Mr. Orton's prediction that the 596 figure would not increase significantly when sources of completions from independent inspectors were factored in was not contested. There's no convincing evidence that the council are suddenly going to exceed significantly their completions for 2020 to 2021. Out of the list of 25 actions, the appointment of one officer, whilst welcome, is a long way from demonstrating that the council have turned the corner. Just taking a look at the projections proves this. The suggested projection next year that the market is going to achieve a massive 1,576 is wholly unrealistic. This is a classic case of the council not standing back and questioning their own projections, despite the clear advice that they should do so from 3 Dragons. It demonstrates beyond doubt a failure to understand the market. That is more than double what they have achieved year on year since 2011-12. How can they possibly justify this? Ma'am, the council are still not living in the real world. The continued use of unrealistic projections cannot be a robust approach on any credible basis. The arrival of the new implementation manager, whilst welcome, appears yet to have had no bearing or influence on the continued reliance of unrealistic projections, as Mrs. Alexander tried to suggest, although in her written proof of evidence, she did accept it was too early to gauge. So, Ma'am, against that background, we invite you to apply Mr. Orton's discount with respect to the supply from the rest of the district. This is set out in the Scotch Schedule, Appendix 1 to the Housing Land Supply Statement of Common Ground. We looked at it yesterday. The council's projections total 1125 for supply over 5 years. Given the highest figures achieved in the rest of the district to date has been 2001, and the average has been 138, simply adopting a projection of 495 in 2021-22 ought to flag up real question marks. Mrs. Alexander simply asserts that the projection is the product of the trajectory, but she fails to consider how realistic the numbers are given what has been achieved to date and wider market issues. Mr. Orton does stand back and factor in these considerations. And so, Ma'am, we invite you to take the actual completion figures for the year 2020-21 and the average thereafter, and that will reduce the council supply by 452. So
That's
that
the
is
rest of district.
Yes, that is 1125, the council's figure, minus 673. And that gives you the reduction of 452. So I think that's quite a discrete discount, as it were, that I'm inviting you to make for specific reasons relating to projections. So, Ma'am, are you happy to? I'm conscious that I know I'm over my time limit. Are you happy to crack on?
Absolutely.
Excellent. Phosphates is the next and final, you'll be glad to know, final piece of evidence that sites are not, in terms of the generic approach, final piece of evidence that sites are not available or offer a suitable location now. The potential for delivery of sites to be affected by this issue is recognised in CD 1107 at paragraph 4.5, as is the fact that a large proportion of the district is affected by this issue. However, there is no indication that the authors of Appendix 1, this is the council officers producing the projections, had the phosphate issue in mind because firstly, they did not ask any question on the 2020 forms about it. Now, you know, how could you might say, it was an issue that had only emerged in August. The council only got the Natural England letter in August. So I'm not criticising them, I'm just simply explaining the chronology. Secondly, if they did, surely they would have identified the relevant information in a column confirming which sites were potentially affected by reserved matters applications still to be achieved, and if all drainage conditions had been discharged. Housing permissions with unapproved reserved matters applications and undischarged foul drainage conditions are plainly caught by the phosphates issue, which itself provides clear evidence why these sites are not to be regarded as deliverable within the next 5 years as at the base date. Because that's the exercise we're doing, we're inviting you to do. We're inviting you to stand, as it were, at the 31st of March 2020. Yes, by all means look forward, but you've got to stand there at that date and ask yourself, are these going to be deliverable at that moment? You cannot be reasonably certain as and when strategic solutions will be found or their extent in terms of how much phosphate emission they may be able to neutralise. There is no evidence that the council has committed to any capital expenditure to acquire land that could be deployed for this purpose. So the extent of any potential solution is unknown, and we do not know how many sites may be able to make use of them. The effects on viability cannot yet be tested. Mr. Orton's evidence in his Scott schedule of contested sites, and these are the contested large sites, has been available since the exchange of evidence. In not one single case where it is stated that Origin 3 have been unable to find written proof of the discharge of the relevant conditions has the council actually produced a clear notice or letter of discharge of a foul drainage condition. That is very telling in our submission. They have not discharged the onus to show with robust, up-to-date evidence in these cases that these sites can proceed now. Equally, this issue also prevents the council from being able to show that there is clear evidence that completions will take place on both the small or large sites with no reserved matters approvals. Both limbs of the delivery test are caught by this phosphates issue, ma'am. Sites that can get away but are in the catchment zone will merely add to phosphate levels, leading to increased nitrate levels and further deterioration of the existing Ramsars. All this just has the potential to make finding viable and deliverable solutions for those sites, so these are the sites that can't get away, which are caught by the HRA issues, all the more complex. This just makes the ability of our site to contribute towards meeting housing land supply and development plan targets without affecting the position at all the more of a boon. Moreover, the council has specifically signed a letter to the minister explaining how they have had to, quote, halt live planning applications and, quote, that this is making it impossible to demonstrate a 5-year housing land supply and meet nationally set planning determination targets in public correspondence. Although Mrs. Alexander's evidence restated the claim that the council have taken a cautious approach, her written evidence, like the November housing land supply paper, provided no actual detail to substantiate this. Nor did her addendum proof of evidence. The potential for this issue to affect viability is also unknown. We invite you to look at tables at the back of CD 1107 and note that no reference is made to the discharge of conditions on the vast majority of the many sites in the many settlements affected by phosphates. At 7107 in his proof, Mr. Orton comments that only 8 sites, that on only 8 sites is a reference made to phosphates. So there are hundreds of sites, and on only 8 of them is there a reference made. The final version of the Scotch schedule of the disputed large sites demonstrated that many more sites are potentially affected by the phosphates. So I just pause there. You know, we ended up with 19 sites on that schedule, and all but 2 of them are potentially affected. It just shows the enormity of the task that the council faces. Shortly before the inquiry had resumed, the council posted a new document on their website, CD 1331, the Phosphates Management Strategy, which referenced developing an SPD to build upon policies in the local plan and provide more detailed guidance to assist in making successful applications. It goes on to refer, and I quote again, to an agreed method and monitoring to ensure phosphate neutral development that can be adopted by all the local planning authorities, which is an easy read and focused on development management and guidance for developers. An initial draft is scheduled to be completed by the end of August. We understand this to be a reference to a Somerset-wide SPD, although the position statement and the suggested dates on the Somerset District Council document is not badged, as it were, as endorsed by the other Somerset authorities working in concert to provide strategic issues to this issue, rather like the Thames Basin Heath authorities did. The note below talks about delivering on the agreed objectives. When I say the note below, I'm still referencing CD 13.31. So that reference to the note below still means CD 13.31, Mum.
Yeah. 13.31.
Yes, it'll be easier when you, God forbid, have to reread this with that document in front of you. The note below talks about delivering on the agreed objectives by autumn 2021. A solution or solutions need to be found. These are my words. A solution or solutions need to be found, costed, and land acquired to deliver off-site mitigation measures. This then needs to be the subject of consultation so that a tariff-based approach can be contained in an SPD. You know, you don't just produce an SPD without public consultation. The very large sites like Brimsmore and Lufton at Yeovil cannot just tap into land planned for further phases of their development to provide on-site solutions. This is quite a nuanced but important point. So moving forward, all but the emerging very large sites need to rely on the as yet unknown strategic, and when I say solution, I really should have said solutions, because I don't believe for a minute that it's going to be just simply one, you know, it's not going to be just one solution. It's neither a Wessex water company offering some trading credits, nor is it the council, maybe council acquired land. It's going to be a number of things. And again, Mom, none of this is in my submission adequately addressed in my learned friend's closing. So it's against that background that I come now to the non-implementation rate. Although the debate about the 19 sites and the care homes, bless you, Mom, requires you to reach a conclusion on delivery rates on these sites, it's not the end of the supply story, as the council accept. The council rightly deploy for the first time a non-implementation rate. I say rightly deploy the rate rather than the 5%, but this is insufficient. It bears no resemblance to the 22% found by Three Dragons over a 5-year period, which is not discussed at all, as I've already observed in CD 1105. Three Dragons could not have factored in COVID and phosphates, as Miss Alexander agreed. Neither factors were taken into account by the council in setting the 5%, again, as agreed was by Mrs. Alexander in cross-examination, nor were the many other reasons why permissions lapse or are not taken up factored in. To continue to maintain the 5% non-implementation is robust when it has plainly not factored in these issues is plainly, in my submission, not robust. Recognising perhaps, ma'am, the weakness of the data that they were relying on, they doubled up the figure to 5%, but they need, in my submission, to go further to take on board the current uncertainty of their projections in the identified settlements, plus COVID and phosphates. We agree, ma'am, that this is a matter of planning judgment and it's not a precise science. Mr. Orton's 11% is, in my submission, eminently reasonable against the backdrop of all the evidence, particularly the Somerset-specific related Three Dragons report. His figures have some objective basis, taking into account COVID, both from the housing, that should be the housing delivery test, HDT, and the Berkshire appeal. Whatever rate, ma'am, you consider robust, it is agreed it should be applied across all the projections. With regard to the large sites on the supply side, we shan't rehearse the round table evidence, but we do, ma'am, just want to make some remarks about the first one on the Scott schedule. So I'm just going to go straight to paragraph 80 and Brimsmore. Brimsmore is a complex site which is being built out from an outline granted as long ago as 2005. To date, with just one lead developer, John Bishop Limited, who have released land to be built to Wyatt Homes, a related company, building out what Mr. Bishop described as an exemplary product. That chimes, the exemplary product point, that chimes with Mr. Orton's evidence. It's the very nature of the high quality product which has and will govern, says Mr. Orton, completion rates. The council introduced 3 recent emails on this site, which are not all consistent, and I summarise them below. I've just put them in a table, ma'am, in a bid to help you, I hope. The first one, and indeed, sorry, I should explain, I've put the large site survey figures in too. The first one from, this is the first email from the head of sales, supported Mr. Orton's projected figures. In the face of that email, the council appear to have gone to another person at Wyatt Homes to seek another view. That is why I wanted to see what had generated, as it were, the email from the finance director. Had the council pointed him to his colleague's email and asked him if these were correct? The finance director provides no explanation as to why his figures are different to the May figures given by his colleague. So we've got one email in May, one email in June from the same company. It's not in my submission for Mrs. Alexander to try and explain away the differences when Wyatt Homes have not done so directly. The new higher projections depend upon the road link. This is my reading, and I'm just going to pause. My reading of the finance director's email is suggesting that. But as Mr. Bishop explains, 25% of the road is already in place. So the road alone doesn't justify an increase in sales as the finance director infers. There's no justification for his projected increased delivery rate based simply on extending the road and opening up more land. As I say, we're talking simply about the extension of a road, 25% of which is already constructed. Sensing perhaps, ma'am, the weakness of their projections, it seems to me that the council have another go with Mr. Bishop. It is he alone who says quotes, with the link road in place, we envisage, that's his language, we envisage the establishment of a second sales outlet. It's the commitment and timing, and it's not a commitment, it's just something he envisages, the commitment and timing to a second establishment and its impact on Wyatt sales has not been evidenced. You can't just introduce a second and think it's not going to affect the first. In any event, the establishment of a second sales outlet is not from a wholly new developer offering a wholly different product. In other words, it will be a similar product. For all these reasons, there is every reason in my submission to be cautious and to look back, as Three Dragons suggested, to inform future projections. And so, you know, in a nutshell, that's why I'm inviting you to accept Mr. Orton's evidence with regard to that. With regard to the care homes, given the age of some of the permissions, the lack of any up-to-date available evidence from the landowners operators of their intention to proceed, the council's estimate that they will all come forward in the next 5 years is not in our submission robust. Mr. Orton's 50% is reasonable in all the circumstances. So, Ma'am, for all these reasons, we invite you to conclude there's no 5-year housing land supply. As I indicated, it would be an acceptable approach to reach an initial conclusion on housing land supply using the standard method, because should, as I anticipate, there not be a 5-year housing land supply, strictly it won't be necessary to redo the calculation with a higher requirement. You know, if they can't do it using their lowest figures, that's the end of it. Should that not be the case, then yes, we do indeed invite you to recalculate using the local plan requirement figure. If you find, Ma'am, no 5-year housing land supply, as agreed in the planning statement of common ground, we set out the policies that are deemed to be out in development, and then I'm going to come on to compliance with the development plan. The end is in sight, Ma'am. We focus on compliance with the SS policies in this bit of the closing. Although Mr. Orton described the SS policies as permissive, he rightly noted that the MPPF 2019 at para 78 is cast in a more positive manner than SS2 and so SS1, which seek to strictly control development. MPPF seeks to promote sustainable development in rural areas where it will enhance or maintain the vitality of rural communities. SS1 and SS2 offers no such promotion or encouragement, rather strict control. The adopted plan offers no opportunity in terms of allocations for such settlements to grow and thrive, and no allocations DPD followed. The emerging SSS4 is in contrast to this approach, as Mr. Kenyon agreed. Plainly, Ma'am, there is no breach of policy SS5. Temple Combe is acknowledged, and this is repeated in closing, thank you, Mr. Robson, is acknowledged to be a sustainable location despite its development plan countryside status. We do not repeat all its positive attributes here, but plainly these proposals are consistent with the objectives espoused in MPPF 78. Policy SS2 emerged late in the day as an added reason for refusal, ostensibly because the council claimed to have a 5-year housing land supply, although compliance or otherwise with SS2 does not hinge on that issue. As Mr. Kenyon agreed, the proposals will provide direct construction jobs and indirect service jobs. If the spirit of the policy is about sustaining economic growth in rural settlements, we see no reason why these jobs should not count towards compliance with the spirit, if not the letter, of the policy's first unnumbered bullet point. Mr. Kenyon gave this significant weight in both his committee report and his oral evidence, and indeed, of course, his written evidence. It surprised us that Mr. Robson felt the need to suggest that this was wrong by reference to paragraph 5.36, to which Mr. Orton was taken, which merely lists examples and is not closed. Increased expenditure in the local economy and capital sums to improve existing facilities, such as the Temple Combe Recreation Ground, will benefit and thus enhance the community. The new publicly accessible Manor Green, overlooked by both the putative and neighbouring residents, is another new facility, which Mr. Kenyon rightly recognised would contribute to a new community facility. It also secures more than ample compliance with EQ5 and HW1. The new footpath will enable those residents living close to the access, including the 2 unbuilt properties. So when I say close to the access, I'm referring there to the
Vehicle access.
yes, yeah, and some of the properties on the other side. Not a huge number, I accept, but there will be some living in that part of the village who will benefit, I suggest, from access to the site and easy access through to East Street and therefore the public right of way, as well as those living closer to the development. So access, ma'am. Oh, what's happened here? Sorry. Yes, sorry. Access to the off-site highway improvements, comma, encouraged from the outset, comma, will also offer benefits to those new and existing residents living either side of Coombe Hill. The single outstanding issue Mr. Kenyon had related not to character but to scale. Having advised you the figure of 35 homes on site should not be regarded as a maximum, he agreed the difference between the proposals, being commensurate with Temple Coombe or otherwise, was 25 new homes. That's what he accepted in cross-examination. Given the scale and character of Temple Coombe, one of the largest rural settlements in the district, this is unconvincing. The proposition that 25 new homes, as it were, is the tipping point. In an attempt to justify this conclusion, Mr. Kenyon plays a numbers game, getting the numbers wrong in the process by double counting Throop Road and assuming everything will come forward. Now, I just want to pause there, ma'am, because there was a paragraph in his closing submissions in which, again, yes, paragraph 55, there's some figures there, and ma'am, he didn't footnote that, but you might like to just note that is derived from 36 of Mr. Kenyon's proof. So this is paragraph 55 of Mr. Robson's closing, and the figures in there. They come from page 36 of Mr. Kenyon's evidence. And I would just like to re-emphasize that he has